Was there a motion to dismiss filed in this case?
There was not. There was a motion to show cause in this case, at least on the affidavit of merit issue.
Is that the way, is that normal under federal rules of civil procedure?
It is not. It is not the traditional way in which a case complaint's sufficiency is tested, or a case's legal sufficiency is tested. But it is authorized by the Delaware law. So the motion was made pursuant to Delaware's law, which permits a party to seek in-camera review, to ask the court to look at the affidavit of merit and determine whether it is sufficient. So that was the motion that was made by all defendants, and that the court then looked at the affidavit and determined it was insufficient because it did not actually include an affidavit.
So wouldn't this have been disposed of in a different manner had this not been Delaware or a state that had a similar requirement?
Yeah, this case would have proceeded instead to continue to expert discovery, where Mr. Berk would have been required to then have his expert testimony disclosed and go through the process of discovery on expert.
Why couldn't they have just made either a motion to dismiss and asked for it to be converted into a motion for summary judgment if an affidavit wasn't provided? They had.
Yeah, yes, Your Honor.
My point is that this is a totally different procedure, correct, than what the federal rules set forth.
It is a totally different procedure. It is a procedure created by the statute to facilitate the procedure created by the statute.
Can I talk to you about, I know you have a bunch of different rules that you say this violates, 3, 8, 9, 11, I don't know, 12. But the essence of all those rules is that the federal rules require a concise and precise statement of your claim.
Yes, Your Honor.
And that it has to be legally sufficient, correct?
Yes, Your Honor.
The affidavit rule instead is talking not about legal sufficiency, it's talking about factual sufficiency, correct?
So that is respondent's position, and I'm happy to embrace it because I think
they're right, it's factual sufficiency, but that's not the purpose of the federal rules, is it?
no, not at this stage of
Not at the
litigation.
pleading stage.
Yes, Your Honor.
All right. Now, having said that, I think you were right in saying that for us or for the court to incorporate 6853, it would be a selective incorporation by us, right? The federal rules require that an answer be served in 20 days. The Delaware rule says the answer doesn't have to be served until until the affidavit's filed. So it's changing all the federal procedural rules as well, isn't it?
Yes, Your Honor.
And that's also why we can't incorporate it, correct?
Yes. I think Delaware designed this statute for Delaware courts as a comprehensive scheme where each of the pieces fit together so that Delaware courts can apply this procedural requirement. But you could only, and I think respondents agree, only bring some of these requirements into federal court. It just would not be possible to bring everything from the Delaware law into federal